My name is Aaron, and I'll be your operator today. At this time, I'd like to welcome everyone to the Problems and Solutions in Identifying and Recording a Work Time conference call. All lines have been placed on mute to prevent any background noise. If you need assistance anytime during the call, please press star, then zero, and an operator will come online to assist you. And I'd like to turn the call over to Mr. Keith Upton. Mr. Upton, you may begin your conference.
Thank you. Before we begin today's webinar, I wanted to cover a few housekeeping items. The presentation will be sent in a follow-up email along with the CLU request form and PHR/SPHR certificate. You may ask a question at any time using the Q&A feature in Adobe Connect. To do so, click your cursor at the bottom of the Q&A pod on your screen, type in your question, and hit enter. The presenters will be answering as many questions as time permits towards the end of the webinar. I'd now like to turn it over to Brian Dixon. Please go ahead.
Thank you, Keith, and welcome everyone to today's webinar regarding problems and solutions in identifying and recording work time. This program is sponsored by Littler and by Replicon. Replicon is a worldwide provider of timekeeping and project management tracking solutions with 7,000 employers, 1.5 million employees across 70 countries. With me from Replicon, who I'd like to welcome to this program, is Praveen Krishnan, a Senior Director in Project Management with Replicon. And towards the end of the program, Praveen will talk to you a little bit about how some of the problems that I identify can be solved through various timekeeping solutions. For those of you who we haven't met before, and of course meeting these days is a bit of a euphemism as it seems to include speaking on the telephone, I'm Brian Dixon. I've had the pleasure of being the co-chair of Littler's nationwide wage and hour practice group. I've been with the firm for a bit of a while. I've started practicing wage and hour law before it became fashionable. And my interest goes both to counseling employers and representing employers in litigation to writing on the subject. I've written and edited the Wage and Hour Answer book, which is a great reference, contributed to 2 American Bar Association treatises, and also contributed to the California CEB book regarding wage and hour law and practice. And in addition to enjoying writing about this subject, what I enjoy most really is sharing my knowledge with employers and helping them problem solve around the kinds of issues that we face today. And we're going to start off with a number of basic concepts, and then we're going to talk about how different activities intersect with those concepts in order to make issues around work time. So going to the first part, and the concepts, we want to realize that an employer has a non-delegable duty to keep an accurate record of hours worked. Well, what do we mean by non-delegable? If you make an employee responsible for keeping a timesheet and the employee does not do so, isn't that the employee's fault? And the answer is no, it's your statutory obligation to have an accurate record of an employee's hours of work, and if that means you have to watch over the employer, you need to do so. You can, of course, discipline an employee who fails to carry out an assigned duty of keeping an accurate record of his or her job, but that doesn't get you off the hook in terms of paying the employee accurately. One recurring question in this regard is, what happens if an employee just doesn't send in the timesheet? And the answer is you have a non-delegable duty to keep an accurate record of the employee's hours of work, and if that means that somebody in payroll has to pick up the phone and call the supervisor, and the supervisor has to try to figure out best he or she can what the employee worked that week, you need to do that. And not providing a paycheck because the employee failed to provide a time card is not really compliance with your obligations under the law. We also want to be familiar with the suffer or permit standard. Most of us really understand what permit means. It means I permitted you to do certain work, but how can I suffer work? I mean, how can an employee inflict work on me? And, you know, most of us are out there cheering other employees on to get everything done. Where does the pain of suffering work come from? And it comes from this. You're responsible for all the work that you knew about or you should have known about. If you as a manager or a manager were to go to an employee and say, I need this report tomorrow morning and it's 5 o'clock and I need it at 8, and by the way, the overtime budget is short, well, you should have known that the employee worked that evening in order to get the report done, and you're going to be responsible for that overtime, whether it was authorized or not. Well, then, what value is the traditional and widespread policy all overtime must be approved before it's worked? Well, it really helps it helps in some regards. It helps shape the employee's expectations so that hopefully employees will speak to you about whether overtime is authorized or not. It will help where the supervisor doesn't know about work that an employee performed. It will not help you where the supervisor knew, as in the example I provided, or had reason to know about the work. And there are cases which are successfully defended on the basis that the employer didn't suffer or permit the work. One example was an assistant grocery store manager who claimed a great deal of overtime after his employment ended on the premise that he had spent hours in the dusting and restacking cans and displays so the store would be immaculate. He admitted he had never reported the time, and he then admitted that his manager didn't know about the time because in his zeal, he did much of this after the store had closed and after everyone else had gone home. And the employer was not liable for that work because it did not know about the work, nor would it have any reason to know about the work. A closely related question, which I run into fairly often, is can an employee volunteer work without pay? I mean, work can actually be enjoyable. Employees can actually want to help out, both out of their own interest and perhaps even when the labor budget doesn't have much room for extra help. But again, if the employer knows about the work, the employer either has to stop the work or pay for the work. In other words, the employee can't waive the benefit of the wage and hour laws. I sometimes translate that into that saying that there are three things in life you really can't avoid: death, taxes, and overtime. One of the challenges that we have if we're an employer that stretches across multiple states is that we have to comply with federal law and with state law. We probably have some sensitivity to that. If we stop and think about the list of all the sources of obligation, it's a little bit sobering because we have to comply with federal law, the law of the state in which we're doing business. These days, local living wage ordinances, which are becoming more and more common. Any collective bargaining agreement we think of as a source of obligation. An individual contract, if one exists, that I promised you this, even if it's in a handbook, as long as you've promised it and the employee accepts the promise by performing the work, you need to comply. And government contractors, service and construction contractors to the federal government, construction contractors to state governments assume special prevailing wage obligations which they have to fulfill. And we can be somewhat taken aback by that, but quite frankly, you're asking the same questions at each level of analysis under each source of obligation. All we really want to do is remember to think through federal law, state law, local law, CBA contract, government contract. And one thing that I'll point out just as a tip is that many employers and most importantly employees think of a collective bargaining agreement as the be-all and end-all of all of one's wage payment obligations, but we often run into issues with respect to whether a collective bargaining agreement provides appropriate compensation. I think the most recurring example is a collective bargaining agreement may say that overtime will be 1.5 times the base rate of pay, but if that excludes shift differentials, lead person premiums, and other premiums, you may be undercalculating your overtime rate. What do we need as a time record? Well, under federal law and the laws of 48 states and the District of Columbia, you only need the number of hours worked in a day. That would be 8 if an employee worked 8 hours, 9.25 if an employee worked 9.25 hours, or 7:21 if you're keeping time in hours and down to the minute. In California and Connecticut, we need clock times as well. California requires the times at which meal periods begin and end to be recorded unless all operations cease at the same time. Basically, that's the concept of the factory whistle blowing and everyone stopping to eat from 12 to 1. But in today's world, how often does everyone sit down to eat at the same time? By the way, one might ask, how often does anyone sit down to eat anymore? One question that I get from employers who don't have a system for recording actual clock times in, for example, 2 states that required is, so what? What if I don't have a record of clock time? The challenge is that if you don't fulfill your statutory, non-delegable obligation to keep an accurate record of employees' hours of work, and an employee proves that whatever record you have is inaccurate, the burden of proof shifts to you to disprove the employee's claim. And that's true, setting aside meal periods for a moment, that's true generally. If your record of an employee's hours of work is proved to be inaccurate or short in any regard, the burden then shifts to you to disprove the employee's claim. And that might be something that you could assume or undertake if, for example, the employee worked in an office or a factory where there are other people about who could serve as witnesses, or the employee worked in line of sight of the supervisor. But these days, many people work away from others. They work in home offices, they work in the field, they work in at a client's location where no one may have line of sight view of their hours of work. And we need to realize that the burden of proof can then become virtually insurmountable. One lesson here, of course, is that you want to make sure that employees record their time daily to ensure that you're getting an accurate record. Okay, I'll wait to the end of the pay period and then I'll go back and fill in my timesheet, be it paper or electronic, is not your best outcome. One other thing that you want to do, of course, if you have the benefit of an electronic timekeeping system, is to make sure that that time record is visible to a supervisor as the pay period proceeds, so that the supervisor can determine who is keeping a contemporaneous and hopefully accurate record of work and who is not. Talk about rounding. Why do we round time entries? Does anyone really know? I mean, is this just a habit that we have that dates back to the time when all payroll calculations were done by hand because we didn't have the benefit of modern data processing equipment? Or is it really just aesthetics? Do we like a paycheck to end in even point, so many dollars, .00 cents? Rounding can help you get there, but is it really worth it? I have one colleague who specializes in rounding class actions who said that you're doing one of two things when you're rounding, both of which are bad. You're either overpaying your employees or you're underpaying your employees, and I would respectfully submit that he's right. If you said that you round because you save on your payroll costs, then I would respectfully suggest that we need to have a side conversation about your timekeeping practices. You can round in a variety of different ways. You can round to the nearest quarter or tenth of an hour. You want to realize that you can't round to any increment of time larger than a quarter of an hour. You can round each time entry, the beginning time entry, the ending time entry for the day, or you might round the total time for the day. You want to think carefully about rounding meal periods because the meal period usually is the statutory minimum 30 minutes. Illinois only requires a 20-minute meal period, but under federal law, we want to remember a meal period, in order to be uncompensated time, has to be at least 30 minutes long, and you have to be relieved of all duty during that period of time. To be uncompensated time in Nebraska and California, you have to be free to leave the premises during your half-hour meal period. Well, how can rounding get me in trouble with respect to meal periods? And the answer is, if you stop and think about it, you could turn a 17-minute meal period into a half-hour meal period if you round the beginning time back to the hour and round the ending time forward to the half hour. So rounding your meal period times is an outcome that can conceal failure to provide meal periods and can lead to a wage claim, possibly a class action, or a Department of Labor audit. Rounding ultimately is permitted so long as the benefit and burden fall equally on the employee and the employer. In other words, the overpayments and underpayments should average out to zero. And you might say, well, gee, my time clock generates this nifty report of rounded time. What do I have to worry about? And the answer is, you should know that every electronic timekeeping system that I know of actually keeps a record of the exact time, down to the hour, the minute, and in some cases the second, of when an employee punches in or out. And in the rounding class actions I've handled, that's exactly what plaintiff's counsel looks for. That underlying record, compares it to the rounded time, and then wants to know where the cumulative effect falls. And, I have to say that there are some favorable decisions on rounding out there. And they're interesting in the sense that some courts will say if some employees are overpaid and some are underpaid, that shows that overall all the employees are on average paid, the employer and the employee are sharing the burden. But I think if I was one of those employees who was underpaid, I might quarrel with that. I'd say my employer or my supervisor, for example, required me to show up 10 minutes early or 5 minutes early from a rounding point of view, or rounding to the nearest quarter hour, in order to open the store. And there's, a systematic skewing of my time, which means that I was always underpaid in that regard. And I think one of the observations made in one of the most recent rounding cases is very important, and that is the court said, not only do I, the judge, want to see that some people came out a bit ahead and some people came out a little bit behind to have a net zero, I want to see that if you look at different periods of time for a single employee, the employee will come out ahead or come out behind, so that there's some sense that the individual employee is not systematically underpaid. And there are ways that rounding can go astray. If employees are told to appear so early, I need you to be here 5 minutes early to make sure that you punch in on time, then obviously you're simply moving the start of work away from where you round the time. If there is a pre-shift report, we could have a problem. If work begins at any time other than the hour or quarter hour, if you're doing quarter hour rounding, or one of the tenths of an hour, if you're doing tenth of an hour rounding, then you will have a systematic skewing of work time. I think one of the most recurring sources of challenges regarding rounding simply is a strict rule against tardiness. If we say you can be disciplined if you are so much as a minute late because this is a time-sensitive operation or you have to relieve another employee, then we know that employees can punch in early and be rounded forward to the hour, but no one's really going to punch in late and be rounded backwards. This was the source of a somewhat humorous incident with one client recently, where the local facility received a new corporate handbook, and it said that employees who punch in more than 7 minutes late will be disciplined for being tardy, and the client was saying, what do you mean 7 minutes late? And when we talked through the matter, it turned out that the corporate office had anticipated that excessively strict penalization of tardiness would affect rounding. There's a closely related concept that we want to know of as a punch window, and that is if I punch in, for example, up to 10 minutes before the shift, my time will be rounded up to the hour, regardless of whatever other rounding rule we have, on the notion that I've punched in to signify my appearance at the job, to avoid having a line back up at the time clock, but I really won't start work until the hour. Well, that's fine as long as you can demonstrate, and of course it's not going to be in a written record, that the employees really didn't start work until the hour. So you'll always have a question of fact if you use a punch window as a means of trying to adjust for either employees arriving early and starting work when the shift starts, or employees punching in and then having some distance to walk to the work area. And I think your solution there really is more time clock. And I would have to say that it would be one of my major recommendations to any employer, and that is keep time to the minute, use more time clocks, have the time clocks closer to the work area, and you'll be able to sleep soundly at night and worry about more important things than rounding rules. Well, how accurate do we ultimately need to be? Will the law really worry about, quote, mere trifles, unquote? And at least in theory, or at least according to the Supreme Court, we don't worry about mere trifles. But the number of times that I see de minimis, excluded work time being de minimis, we really didn't have to trifle with it as a defense, is disturbing. And quite frankly, if you are raising, oh, that's just de minimis time as a defense, you are basically on the ropes. What does de minimis time consist of? It really is defined by three factors: the administrative difficulty in recording the time, the amount of time at issue, and the regularity of the activity at issue. And I have to say that courts have been quite forgiving on occasion, depending upon your judge, so to speak, of the amount of time that can be excluded. In some cases, courts have forgiven employers up to 10 minutes per day. But you need to realize that as the amount of time at issue gets longer, the courts become much more affirmative about there being some administrative difficulty in recording that time. And sometimes you'll find a sympathetic court that will stretch. One recent court said login time in a computer call center or customer call center was de minimis, in part because employees varied in their dexterity in terms of how quickly it took them to log in after they hit Control-Alt-Delete in the morning. Well, I would love to have that judge on any one of my cases, but I would have to respectfully submit that that's a little bit of a stretch from de minimis work time. And one other aspect of an administrative difficulty in recording the time is whether there's a practical difficulty in recording the time, such as that activity necessarily occurring before the time recording system can be accessed. But as said, if you're relying on that time is so de minimis as not to be trifled with as a defense, you are on the ropes. The referee has started to count, and you can find a substantial number of cases where the referee's count comes in increments of $100,000 or more if the referee believes you've taken excessive advantage of the exclusion of work time. We also want to realize that as technology gets better, there are fewer excuses for not capturing all work time. And rather than flee from that technology, I would suggest that we embrace it and use it in order to create the best possible record we can. Well, when does work actually begin? And, one of the great mysteries of wage and hour law, of course, is that Congress wrote the Fair Labor Standards Act in 1938, the worst year of the Great American Depression, defined the minimum wage, defined overtime, both driven by hours worked, and if you look in Section 3 of the Act, you can find a list of definitions where there's a definition for virtually every letter of the alphabet except we're missing a definition of work. Well, it's only one of Congress's several lapses in drafting the statute. And the definition of work was left to the courts, and the Supreme Court struggled with it and initially said work is physical or mental exertion, primarily for the benefit of the employer. And then that evolved a little bit, and that is the work can actually be doing nothing, such as an employee who's told, show up and wait, I need you to be here so I can immediately get you going when the process starts. So the physical or mental exertion need not be burdensome. And this eventually evolved into a Supreme Court decision in the 1940s where the Supreme Court said that walking time from the time clock to a work area was work time. And that aroused the ire of Congress, which then passed the Portal-to-Portal Pay Act. And the FLSA, the Federal Overtime Law, has to be read in conjunction with the PPA, or the Portal-to-Portal Pay Act, to understand your obligations. One thing that the PPA introduced was the concept of the regular workday. And I don't mean workday in the sense of 7 consecutive 24-hour workdays add up to a work week. I mean workday in the more conventional sense of I have to be paid for all my time from when my day begins until when it ends. Something a layperson might think of more akin as a work schedule. And the rule of the PPA is that once a workday starts, all of an employees are work until it ends. And there are some exceptions, of course, that spring to mind. Meal periods would be one. Travel to work is generally not work time, but once travel falls within the regular workday, from a job to job, it becomes work time. And one example of how the workday is important is a case concerning bus drivers who worked a split shift. They were busy in the morning getting people to work and to school, and they would have a gap in the middle of the day, and they'd be busy in the afternoon and early evening getting people home from shopping, work, and school. And the court said that, and the bus drivers had to get to the spot from which the bus left, which wasn't the bus garage, was wherever that bus happened to be en route, so they could relieve another driver. And the court said getting to that initial starting point of the bus route in the morning and getting home from the end of the last bus route in the afternoon is not work time, But then the court said the intermediary travel at the end of the morning split shift and before the afternoon split shift was in fact work time. So we can see how the rule changes based upon whether the activity falls within the workday or not. And we want to be aware that courts are reluctant to find gaps in the regular workday apart from meal periods and relatively long periods when employees are relieved of all duty. In some cases, courts have said 2 hours or more would be needed in the way of a break before that regular workday would be interrupted and you would have a period of uncompensated time. We'll see some applications of the regular workday as we proceed with this morning's program. One other thing that the Portal to Portal Pay Act tried to do was to provide a little shape around where exactly does the workday begin and end. And the Portal to Portal Pay Act excludes preliminary and postliminary duties. That, of course, again, left the courts a little bit high and dry, and they struggled with that. The Portal to Portal Pay Act also excluded walking, traveling, riding, as long as it was before or after the regular workday. But we get trapped in something of a circle. We're still left with where does the workday begin? And again, we'll be talking about that in a few minutes. Could Congress have given us the circular definition? They did, and the courts have struggled. The Supreme Court's initial formulation was that a preliminary and postliminary duty could not be one which is integral and indispensable to an employee's primary duty, such as a butcher sharpening a knife. Courts have, and I think each circuit court across the United States has a different idea of exactly what should be considered. One handy set of factors is whether the activity is required by the employer, whether the activity is necessary.
Is that right?
Yep.
Okay.
We had a little interruption on the line there.
Mayu, can you please mute your line if you're not speaking?
Mute the phones.
I think you're all set, Brian.
And thank you. And whether the activity primarily benefits the employer. So we have three factors: whether the activity is required by the employer, whether it is necessary to perform the work, whether the activity primarily benefits the employer. And there's some really great examples of that in some very recent cases concerning security checks. Take, for example, an employee who works in construction and is working at an airport and has to go through airport security in order to reach his or her job site. Do we have to start paying the employee from the point at which that security check occurs? The court's analysis: well, the security check isn't required by the employer, it's required by the Federal Aviation Administration. Is the security check necessary for the employee to perform his or her duties? Well, in a sense, yes, because you have to get to the job site, but we all necessarily have to get out of bed in the morning in order to go to work, so it's not really necessary in the sense that it's part of the job. And whether the activity primarily benefits the employer, here it doesn't. It really just means a little more hassle for the employees and perhaps a delay in work being started. And, the employer would prefer, setting aside concerns of national security, that there were no security checks at all. So in two cases, that kind of a security check has been found not to trigger a start of the workday. Well, let's take the same thing and look at another kind of security check, and that is retailers, especially those of high-value products, of jewelry and electronics, often have a security check at the end of a shift as employees leave, just to make sure that the shrink doesn't shrink more than the shrink can be expected to shrink. Somewhat sad observation there. And often, because a bag check has to be done, some scrutiny has to be exercised, the shift ends at the same time for everyone at once, lines can form, and it might take 25 or 30 minutes to get through security. If we apply the same criteria, we come to a different result. Same criteria is used with respect to the security check at the airport. When applied to a security check for shrink or loss prevention purposes, you get a different result. The activity is required by the employer. It's not required by law. The activity is necessary for the employee to perform his or her duties. No. but that's only one of three factors. And whether the activity primarily benefits the employer, well, it certainly does. It's designed to avoid shrink. So you can get a different result depending upon how that security check occurs. One thing that I want to emphasize is that the Portal-to-Portal Pay Act, which limits work time under federal law, does not appear, and in fact, it's rare to see anything like it in a state's labor code. Some states will treat the Portal-to-Portal Pay Act as something of an exemption from the general obligation to pay wages, and if it doesn't show up in their labor code, they'll say the Portal-to-Portal Pay Act is irrelevant, and that state will apply a stricter standard as to when a certain activity is work or not. Other states tend to take a little more benign view and simply say, we don't define work, we'll look to federal law defines work, that's sufficient for us. Let's look at some of the activities, and we're now going to go to the second part of the program, which is looking at specific activities and how they relate to when does my work start and when should I be recording work time. And we need to lead off with donning and doffing. And one would think that one could get some reasonable or specific rules around donning and doffing, but I think if you sat and you counted cases, wage and hour cases, about work time by subject matter, you would discover that there are more cases about donning and doffing than any other work activity. In fact, probably most other work activities combined. And in some regards, that's to be expected. There are many, many varieties of donning and doffing activities, everything from a bellhop putting on a uniform to a serving person in a restaurant doing so, to a chef putting on his or her whites, to a construction worker putting on safety equipment, to a someone working in a production line doing the same thing, to a policeman or a police officer putting on not only a uniform, but also putting on a holster, a gun, handcuffs, a bulletproof vest, and a shield on that uniform. So we can empathize a little bit with the variety of different circumstances they face. For today's presentation, I'm going to break donning and doffing down into three basic rules and talk about some of the variations that can arise. The first general rule is that if you can put it on at home, it's not work time. This was emphasized recently by a decision coming out of Arizona, where police officers claim that they should be paid for the time that they put on their uniforms, and not only that, for the commute time from home to work, because that would be part of the workday. But the Court of Appeals rejected their argument, saying that it might have been convenient and perhaps even appropriate to put on the uniform at work, but as long as it could be put on at home, it would not be work time. I would point out that the general rule that if you can put it on at home is not work time has occasionally sparked some dissent. There was a judge for the city of San Leandro here in California addressing an issue at the city of San Leandro, said that putting on the holster, handcuffs, and security vest, the bulletproof vest, could be considered to be work time even if done at home. So again, we want to realize that we have some general rules and exceptions, but I would certainly recommend that if you have dress requirements for your employees, you carefully consider whether they're work time or not. The second general rule is if you have to put it on at work, it's work time, because the employer is requiring you essentially in some cases, depending upon how much you have to put on, if you have to put on a uniform at work, requires you to repeat the process of getting dressed for the day, and that's certainly for the employer's benefit under the employer's control and the like. There are some exceptions. For example, a court of appeals in New York concluded that putting on personal protective equipment that was of a generic nature, not unique to the job, but generic, the hard hat, the steel-toed boots, the earplugs, and the safety glasses, would not be considered work time. While it was an integral part of the job, it was not indispensable to performing the work at issue. I point out that not every court agrees on that subject matter, so again, caution should be exercised. And we want to realize, of course, that when we talk about individual items of clothing being put on, for example, a hard hat, a pair of safety glasses, and perhaps earplugs, that we get very closely related to the concept of de minimis work time. One court pointed out, after reviewing a videotape of employees, quote, work of putting on generic personal protective equipment, was that most of them did it while walking in mid-stride from the time clock to the work area, and the court was hard-pressed to find that they spent any appreciable amount of time in addition to the walking in order to accomplish that. But you can get very interesting litigation out of these. We had one client whose handbook, unfortunately, was somewhat ambiguous, and at one point it seemed to suggest that you had to put on and take off your uniform at work, while in another location it actually said you could change at home if you wanted to. You could take your uniform home with you. The court said they would hold the ambiguity against the employer and certified a nationwide class at that point. So we want to, the real takeaway at that point is, if you are going to let the employees change at home, you want to affirmatively announce that to the employees, make sure they have sufficient changes of uniform so they can conveniently change at home. Just to show you how far some of these cases can go, we had another case where a class action, it was actually the fourth of class action involving the same change of clothing, and unfortunately the jacket had in the back of it a little tag that says press with cool iron only. So a class action was filed by an employee who said, I diligently pressed my clothing every day with a cool iron. The discovery, of course, was interesting. We had a broad range of responses there. There were some employees who testified, I never pressed my uniform. Those people, of course, were easy to identify by their rumpled look. And we had, a few employees who said either my girlfriend or my boyfriend does the laundry, I delegate that, and they, of course, were promptly promoted into management. But the general rule is if you have to do it at work, it's going to be work time. There is one exception here that I would really point out. It's very important, it's very timely, and that is there is a carve-out from the FLSA for clothes changing and washing, where clothes changing and washing are excluded from compensable work time by the terms of or under a practice arising from a collective bargaining agreement. And I say this is important because the Supreme Court is in the middle of accepting briefing on this subject matter. There's been a split in the circuits on the subject. A lot of that split concerns personal protective equipment and whether clothing, as used in the FLSA, should be extended to include personal protective equipment. It's a close question. The Department of Labor, for example, initially opined that personal protective equipment was not clothing and could not be excluded from compensable work time by a collective bargaining agreement. Under a late administration, the DOL flipped and said the opposite, and most recently the Department of Labor flopped and said again what it had said in the first instance. And fortunately at this point we'll get some guidance from the Supreme Court. The third and last general rule is that changing and showering that are made necessary by the job itself is considered to be work time. If, for example, you work in a battery plant where there is frequently, if it's a lead-acid battery, a very common type of battery, there may be acid, you may be exposed to acid, the changing and showering would be considered to be integral and indispensable to the work, and you would have to consider it to be work time. Where exactly does the workday start in other regards? And you can get an exceptionally close scrutiny as to even what appear to be incidental activities. For example, I had a Department of Labor audit where housekeepers picking up keys at the security station was argued to be the beginning of their workday, and the issue, of course, was that the housekeepers had to walk some distance at this resort in order to get to the housekeeping office where they would punch in. And we have arguments persistently with the Department of Labor, where an employee goes to, a construction employee goes to the employer's yard in order to catch a free ride on a company truck to the job site, so the employee doesn't have to pay the gasoline cost of getting to work in the morning, but the employer makes job assignments in the yard in the morning, or says, okay, this is what we're going to do today. Even those kinds of things can be considered to be starting the day. So the rule really here, again, is more time clocks, more places, closer to the work is a good thing. One other thing I'd point out is, we might sit here and think, well, geez, isn't picking up the key sort of a de minimis activity, and how long does it take for a foreman to say, look, you're going to go to the ABC job at the corner of 1st and 2nd Streets, and it's de minimis. But in one of the more recent Supreme Court decisions about clothes changing, donning, doffing, and de minimis, there was a throwaway sentence which said that a trial court could consider not only the alleged de minimis activity, but walking and traveling after that activity to see if in total there was the de minimis doctrine should apply. So we do want to be very sensitive to the fact that de minimis activities are based, if you're defending a case on the basis that the activity is de minimis, you are essentially moving backwards and not forwards. What about walking time? Well, the Portal-to-Portal Pay Act clearly excludes walking time before and after the regular workday from compensable work time. And again, we get back to, okay, when does the workday begin and end? And we know that just punching in as a time clock under the Portal-to-Portal Pay Act doesn't trigger the start of the workday. But again, we want to look back at some of the activities we've talked about and think about them as whether they start the workday. Donning and doffing a uniform, or perhaps that hard hat, those glasses, and the earplugs. Getting instructions from a supervisor, picking up keys, loading a vehicle in particular. A recent case addressed to that. Booting up a computer. There are innumerable call center cases that concern booting up a computer. And we need to appreciate that if that is found to be work time, again, the walk time could be triggered or turned into compensable work time. There's another very interesting and recent case that turned a little bit of the regular workday upside down, and it involved walking to a meal period. The court pointed out that walking from the time clock to the place of work within the employer's facility was not work time. The employees complained that they had a long walk back to the lunchroom, and that their meal periods were therefore not 30 minutes long because the meal period was measured from when they left the work area. And in a case which I think is a very good case to keep in mind as an example, the court said the walk time from the work area to the lunchroom would not be counted against the meal period under federal law. The plaintiff at the last minute threw in, but under Nevada law, they have a more strict standard. And the court remanded to the trial court the issue about whether the walk time shortened the meal period such that the meal period would be compensable work time under state law. So we see a little bit of a variation there on a court's interpretation of what is the regular workday and what activities within the regular workday are work time under federal law. And we are reminded in a very important way that states can vary from federal law as to what is compensable work time. Let's talk about travel time and commute time for a moment. And here, when I talk about travel time, I'm not talking about the special one-day trip out of town, or as some of my clients do, they will on occasion fly a non-exempt employee a long distance, either to Europe or the Far East, in order to perform some key site. Key activity. What I'm talking about is travel on, for example, a company bus to a job site. And that kind of travel is not work time, even if it's of a very substantial distance. In a case arising out of Texas, field workers who had to go to a particular location to get on a company bus to be taken to whatever field they were working in on a day did not have to be paid for that time, even though it was a 2-hour trip in each direction. We can, of course, turn that travel time on the bus into work time, and it's very common in travel time cases to see allegations that While sitting on the bus, the foreman would hand out instructions for the day. The safety meeting for the day or the week or the month or the quarter would be conducted while on the bus. That instructions would be handed out that had to be read. And of course, if we want to preserve that travel time as non-work time, we want to affirmatively advise supervisors not to use that travel time for any other purpose. Commute time, and we can think of commute time in two senses. One is commuting in my personal car to work. Is that work? And, in the general scheme of things, no, it's not work. But where work is more and more mobile and can be performed at home as well as other places, you do see cases where employees argue that driving from home to the office or to my work site is work time. And the continuous workday rule applies, so what looks like the home-to-work commute is really job-to-job commute. Most of the courts have concluded that where the employee has an appreciable range of time in which to perform any work at home, such as, look, I just need you to upload the day's work results from your service calls sometime in the evening, that flexibility allows the employer to consider the commute home not to be work time. But that tells us something very important, and that is we never want to write a policy that says, for example, I want you to check in by phone or by email or to log in immediately before you leave the house to see what the day's job assignment is, because you might turn the commute into work time. Similarly, if you say, I need that upload to occur as soon as possible after you get home, you should walk in the door and give me that information, you jeopardize being able to consider the commute home as non-work time. And there's another variation here, and that is the worker whose job is to work at home. And there, the Department of Labor has, for example, taken the position that remotely based workers, someone, for example, in the insurance industry, claims review, for example, who works at home 5 days a week, has a home office, and their travel away from that home office to, for example, the once-a-week in-person meeting in the company's office building is working while traveling to that meeting. Similarly, there was a case in Massachusetts where insurance adjusters who were home-based and who rarely saw the office, they would get their assignments for the day, they would file their reports all from home, they would go out and meet insureds who had accidents and sympathize about the loss and talk about the cost, were working while they were commuting from their home offices. And in that case, those were home office-based employees. The plaintiff, for example, testified that he would do an hour or two of work online in the morning, then go see his insureds and their damaged cars, and then come home, and he inevitably worked for an hour or two in the evening. So his claim, of course, was that he should be paid for the commute both ways. And again, the practical suggestion there is that if you do need to have such an arrangement, you might think about making sure that all the work falls on one side or the other side of the day. The second aspect of commuting is commuting in a company vehicle, and under the Portal-to-Portal Pay Act, use of a company vehicle to commute is not work time, as long as the employee incurs no cost in the operation of the vehicle. The vehicle is the type that is used for an everyday commute. It's not a big, heavy truck with a crane on it. And the commuting is with the normal commuting radius of the employer's office. You do need, again, to watch things such as logging in to get my work assignments, uploading my results of the day. We want to know that that exclusion, that special exclusion under the Portal-to-Portal Pay Act, extends to activities incidental to the commute, but we don't have a lot of guidance around incidental. I think you're much better off if you're using such arrangement to make sure that all administrative work is performed using the air card during the regular workday, and we really limit what happens at home. Again, we want to be sensitive to the fact of both state law and federal law. In one of the really favorable cases under the Fair Labor Standards Act, the federal overtime law, the court said that a field service technician who drove from his home to various service sites in the course of the day was not working under federal law, where the employee, even though the employee could not carry any passengers in the vehicle, very common insurance limitation. Had to go straight from home to the first job, couldn't run any personal errands, had to monitor the cell phone while on the way to the job. Was still not working under federal law, but remanded that case because state law might consider that same commute to be work time. And that can be an issue in a variety of states. Washington, for one, is much more expansive in considering commute time and travel time to be work time than are many other states. Recording remote work, work at home. Well, work at home was homework when we were in high school, and then now it's just work when we do work at home. We do want to make sure that we can accurately record work at home because it still is work. And having a timekeeping system that gives you the flexibility of remote time entry, of course, is a good thing if we're expecting employees to have that flexibility. We don't really want to have an employee having to make little handwritten notes on Post-its and bring them to the office to remember to write down what I did last night. You may have seen, cases about BlackBerry time and smartphone time as work time. The challenge with those cases as class actions, the challenge to plaintiffs, of course, is that employees vary very substantially in what work they may be expected to do or actually do in the evening or on the weekend. And, just checking the phone occasionally for messages is likely to be de minimis. But people don't check phones for messages and then don't do anything about the messages. So once we roll over to please check, then we need to expect that there's going to be some additional work. And typing on those little bitty keyboards is certainly very time consuming, especially if you want to eliminate all the typos. So if you're expecting non-exempt employees to be checking their remote devices or their devices when they're remote from the office, make sure they know that they can record the time. Your maximum vulnerability, of course, would be creating a sort of unspoken expectation that thou shalt check the smartphone and having at the same time an unspoken expectation that you don't really record that time because it's sort of de minimis. We just need to be realistic about if people are expected to check their work remotely, they should be given the opportunity to record the time. And if you're feeling that, hey, our minimum timekeeping increment is a quarter of an hour, and why should I pay a quarter of an hour for what may be 5 minutes of work? The 5 minutes can add up, especially if an employee is expected to regularly check their phone, and you might be thinking about it'd be better to record or round your work time in tenths of an hour rather than quarters of an hour. I had a client who actually had an expectation that her employees would check their phones every 2 hours on Saturdays and Sundays, and do I need to pay for that time? I want them to check, but very rarely is there anything to do. Well, at the end of the weekend, you might say if the employees were 25 years of age or less, they probably never stopped looking at their smartphone over the weekend and spent most of their weekend texting. But I think more realistically, we should provide at least some compensation for that time. And I will briefly mention social media. If you are an employer who markets your services by encouraging employees to use social media, to have accounts on Twitter or LinkedIn, or to work through Facebook to market the company's products or to keep up with developments, you really are well advised to draw much brighter black and white circles around what is work time and what is not, and what is expected to avoid problems. Now, for those of you on the East Coast who are well into your personal meal periods, I'd want to say that we need to be very prudent, as I discussed earlier, about recording meal periods. It's particularly true in the 21 states that have some form of affirmative requirement to have a meal. We spoke a little bit earlier about we want to make sure that we can show that the full 30 minutes were taken. For example, in Oregon, I've had a case where an employer was penalized for providing meal periods that were only 27 minutes long. There was a jury verdict here in California where an employer was found liable for meal periods that were shorter than 27 minutes long. And I don't mean to suggest that 27 minutes is a safe harbor. What I mean to say is if the meal period is supposed to be 30 minutes, you want to make sure you provide that 30-minute meal period, and you want to make sure that you have an accurate record of that meal period so we don't have the 27-minute blues. One common issue with respect to recording meal periods is, hey, can we do that by exception? Do I really need to burden the payroll system with employees, clicking in, punching in and out for lunch, and they're going to stand in line, and there's 1 or 2 minutes, and they're going to complain or grumble? In other words, can we just do the meal periods by exception? And I would start this conversation by noting that when I was on a panel recently, a plaintiff's counsel appeared on the panel with me, a colleague who I respect a great deal, and whose one-sentence characterization of exception reporting for meals was that it was an invitation to a class action. And I think that's true. There was a recent favorable case out of the Midwest on, I think it was Missouri, on exception reporting for meal periods. The court said you can actually do it and it's okay, but you have to have a well-disseminated policy. You also have to well disseminate the exception process, and the judge, better well see that employees can readily use that in order to claim missed meal periods. And in that case, the court's orientation was more whether this should be a class action or not. Certainly an employee who felt coerced into not taking a meal period could file an individual claim. What about rest periods? Do we want to record rest periods? And I would say as a general rule, no, simply because if you say, I want you to record every rest period in the half dozen states where rest periods are required, employees are inevitably just not going to get there. It's too burdensome. You're not going to be able to have a complete record. In fact, what's going to happen is you're going to create an adverse record because those employees who just don't want to be bothered and don't punch in and out for the rest periods will be creating a record that could be used against you. That's not to say that rest periods are to be ignored from a timekeeping point of view, and I will point in particular at 2 states. Here in California, of course, if you do not provide the required number of rest periods and meal periods in the course of a day, that is, provide the opportunity to take them, you have to pay an extra hour of pay at the regular rate of pay for 1 hour for however many rest periods are missed and 1 hour for however many meal periods were missed in the day. That is, missed in the sense that the opportunity was not provided. So obviously, your timekeeping system has to have some means of recording missed meal and rest periods, and you have to pay that 1 hour pay on a timely basis, or you get, another, famous California double whammy. You not only have to go back and pay for the missed meal and rest periods, you have to pay civil penalties for failing to pay all wages when they were due. We also want to be sensitive to a related but very different rule arising out of a Supreme Court decision from Washington in October of last year, where the Washington Supreme Court said, without any particular statutory requirement for a penalty, that if an employee missed a rest period, the employer didn't provide the opportunity for the rest period, the employee should be credited with an extra 10 minutes of pay. So if 2 rest periods were required in a day and 2 were missed, the employee would actually have to be considered to work 8 hours and 20 minutes, and that 20 minutes could count towards overtime. So when we look at Washington, of course, we need to know that we need a timekeeping system that will allow us to record missed rest periods so we can pay the additional increment in work time. Well, assuming that we don't want to record every rest period, what is it that we would like to have from an employee? And I think you want to have from every employee a certification that the time card is complete and accurate. And certifications can come in any of a variety of means. At a minimum, I think you want a certification that I accurately recorded all my time for this period. It would be nice if it went on to say, and I have not, just as a reminder, I have not performed any work off the clock, which would be considered to be work time. And certainly if we're concerned about meal periods or rest periods, we would want to have that certification go on to say that I was provided all of my meal periods and rest periods, and I either took them or waived them voluntarily, or I accurately recorded above or on my record when I missed a meal period. So, and the third evolution there really is to become more specific, and of course, you're probably thinking more legalistic, but if your certification can cross-reference your policy about meal periods and rest periods, you're just going to have a more robust certification. And of course, then we're thinking about what can the timekeeping system do for me in this regard? Can it generate a pop-up? Can I have an electronic signature? And yes, an electronic signature would work. Speaking of meal periods and rest period policies, we want to remember that most of us think of the Brinker Restaurants decision in California as a positive outcome for employers, but one of the little plaintiff type of barbs in it is that if your policy as to meal periods or rest periods is deficient, then a class can be certified. And again, we want to remember that there are 21 states that have meal period requirements. A subset of those states have rest period requirements. They vary materially. New York, for example, has very complex timing provisions as to when meal periods are to occur. Oregon has a special notice that has to go to an employee if an employee is going to work on-duty meal periods. And then we get the range all the way down to Wisconsin, where meal periods are recommended, but nothing more. But, perhaps Wisconsin relies upon that internal time clock, the stomach, for saying when it's time to eat. Another good thing to have in any certification, of course, is to have a simple statement that I know that I can contact human resources at this email address or at this phone number if I have any questions about how I should be paid or any concerns about how I was paid. I cannot say, and I would strongly recommend that sign appear next to the time clock if you can't generate it electronically in an electronic timekeeping system. It is certainly a prudent idea to keep as many possible issues within the company. And let's talk about editing time, especially in, you can edit time both on a paper time card and in an electronic timekeeping system. Years ago, I can remember doing an administrative hearing where an employee claimed that he or she had not been paid for all of his or her work time, and the employer had used whiteout. This does date back a little ways on the time card and obliterated what the employer thought were the incorrect time entries and written in the correct time entries, and we could see suspicion growing on the face of the hearing officer until we discovered that the employer had used a very modest brand of whiteout, and if we held the time cards up to the sunny window, we could actually see the original time entry, which were, as the employer pointed out, very little different than those which had been penciled in as corrections. I was sitting through the modern version of this just the other day when a Department of Labor audit started, and the Department of Labor auditor went through all of the questions in the standard checklist and then, digressed in an interesting fashion, which is to say, can supervisors edit work time in your system? And if so, is there an audit trail? And if so, do you ever look at the audit trail? Which, of course, is a good thing to do. In any electronic timekeeping system, you want, at a minimum, the timekeeping software to generate a report of who edited time, when, in what amount, and why. In an ideal world, you would be able to go back and search, say, by supervisor, to review all of the supervisor's edits to see what was added, what was subtracted, how many changes were made, how many missed punches had to be corrected. And you want to do that for a variety of reasons. One, in an era of tight labor budgets, I have to say there's a very fine line between editing time to make sure it's accurate and the occasional unfortunate shaving of time to try to meet the labor budget, and you, of course, want to be sensitive to that. You also want to be sensitive to the fact that excessive edits and excessive missed punches are telling you that your supervisor is not performing up to the standard you want. That supervisor is failing to train the employees to do what they need to do in the timekeeping system, and you need to support that manager and, if necessary, counsel that manager about the need to proceed. One last observation I would have is in all of the cases that I've had regarding rounding and off-the-clock work, whenever I interview the supervisor, if there's a missed punch, the supervisor inevitably says, and I entered the scheduled end of the workday. It always seems to be the end of the workday that's missed from a punch point of view. And quite frankly, the supervisor should be checking to see if, in fact, that was the end of the work time for the day. Putting in the scheduled work time is, in many regards, just a little too convenient. Record retention. Well, what drives record retention, of course, is the need to respond to wage claims. And we want to realize that under federal law, the basic record retention period is 2 years for all time cards, but the 2-year statute of limitations can be extended to 3 if the employee alleges, as the employee inevitably does, that the violation was willful. So keeping the time cards for 3 years is well advised. As we look around the United States, we want to be extremely sensitive to the fact that the state statute of limitations can be longer than the federal statute of limitations, and we have to plan accordingly for keeping records of work time and compensation. The longest statute of limitations for a wage claim is 6 years, but when we stop and think about that, that can be a very long period of time indeed. I have one case now pending in Kentucky where plaintiff argued that Kentucky's 14-year statute of limitations for claims on contracts should govern a wage claim, and you can imagine the challenge of going back 14 years to determine whether someone did the work and what they were paid for the work, and was the supervisor 14 years ago still with us, retired, or perhaps gone to the great beyond, shall I say. And lastly, we want to think about providing records to employees upon request. Again, it's very important for the employer to be able to respond effectively to an employee regarding records to keep any dispute enclosed within the company, or at least initially raised within the company, so that it might be most conveniently resolved within the company. Some states do have statutory mandates to provide those records, but quite frankly, if an employee ever approaches you and says, "I'd like to review my pay records," I would comply, and I would say, tell me what's troubling you. Let's sit down and talk about it, and again, resolve it before the employee feels sufficiently frustrated that the employee looks for outside counsel. And for those of you who need some inspiration or reinvigoration as to the importance of keeping accurate and complete time records, I would suggest that you merely go to your favorite search engine and type in overtime claim, and you would have so many pages of plaintiff's lawyers who would just be more than eager to assist you with your claim, and perhaps all of your colleagues, that if an affirmative desire to get things right is not sufficient, the fear that you can feel when you look at that infinite number of plaintiff's lawyers should get us to where we want to go. And with that, I'm going to conclude the initial part of my presentation here today. We will take questions and answers, but what I'd like to do at this point is let Praveen speak to some of the electronic solutions that exist for the problems that I've talked about. And I'm going to review the questions that have been kindly submitted while Praveen is speaking with you, and then we'll return to questions and answers at that point. Thank you. And Praveen.
Thanks, Brian. Thanks for that engaging and enlightening presentation. Hello, everybody. My name is Praveen Krishnan. Hope you can all hear me well. I'm the Senior Director of Products at Replicon. We are very pleased to bring you this webinar today, and we hope to make this a recurring series. So we've received a lot of questions, and Brian's reviewing them. But before we jump into the Q&A, I'd like to take a couple of minutes to tell you about Replicon and how we can handle some of the issues that Brian brought up. We are the leader in cloud-based time tracking applications. We have over 1.5 million users from over 7,800 customers spread all across the world. Our time and attendance management suite has helped thousands of organizations decrease their labor costs and keep them in compliance with the myriad labor laws that are at the federal, state, and local levels. Our motto is no hassle, and we actually take that to heart across all our teams in Replicon. We believe that enterprise software should be simple and easy to use and really easy to administer. And for whatever reason, enterprise application companies don't seem to care much for usability. So getting employees to fill in timesheets is hard enough, so a terrible user experience just makes the employees hate the chore even more. So in addition to having deep time and attendance functionality, we have a huge focus on usability for all users. Our UI is very Web 2.0, and people, are very familiar with that kind of an UI and find it easy to use. Replicon is a true cloud application, so our application scales based on load. Updates are quick, and you're always on the latest and greatest version. Now, being a cloud application provider means that we spend more time and money on security than the entire IT budgets of most companies. And in addition to that, our infrastructure undergoes frequent security audits to ensure that we don't miss anything. And this is one of the reasons why several large financial institutions, a lot of the companies trust us with their data and their processes. We also have a very open integration platform, so we fit neatly into business processes. So we integrate with most major HRIS systems and almost every major payroll vendor that's out there. Time Attend is our time and attendance application. As I mentioned earlier, we make it really, really easy for employees to fill out their timesheet. So there isn't a lot of excuses for employees to fill in a timesheet incorrectly. And we have a lot of validation rules that prevent errors from creeping in at the beginning so that it's not expensive for you to fix it later on. We have a very configurable rules engine where all kinds of overtime rules can be configured. So any kind of state, federal, local, collective bargaining type of rules can be set up in the system. In addition to that, we also have the ability to automatically flag meal break violations, things that Brian brought up. You can very quickly track when somebody is not taken their meal like they're supposed to and address it quickly. Now, of course, we have a full-featured set of mobile applications that are available on iOS and Android. And on these applications, you can fill in timesheets, request time off. Supervisors can very quickly approve timesheets, time offs, and expenses. And it's all fully integrated with our application suite. Now, for companies using expensive time clocks, and I say expensive because most of them are expensive, we offer a very unique solution. We call it the Replicon Cloud Clock. It's an app that gets deployed on an off-the-shelf tablet. So, like a Galaxy tablet or an iPad. An employee, once it's deployed, it could be set up anywhere in the premises. And employees walk up to it, flash their ID cards, it registers a punch, and takes a picture. So now you have a photo audit trail that can deter buddy punching without the need for complex and expensive biometric readers. Now, the entire solution that we offer as a Replicon Cloud Clock is at a fraction of the price of a regular time clock that you probably have. And you get buddy punch protection, time entry, time off management, and a lot more functionality. With the low cost of tablets these days, typically less than $200, you can afford to put these clocks all around the office. Plus, these tablets aren't ugly gray boxes that you have to hide in the back room, so they also look good at the same time. So that's very quickly about what we do and what we have. So our applications, in addition to tracking hours for payroll, we have modules that let you track hours at the same time towards departments and products and such, so that you can do cost management and so on. We also have a separate module that you can use to track time off for your exempt employees, which does accruals and things like that. So with that, we do have some questions for you. So Keith would be putting up a poll on your screen. We'd be really interested to hear from you. And if you'd like to learn more, please contact us, and we'd be happy to talk to you. And I'd like to turn it over to Brian for our Q&A. Thank you.
Great. Thank you, Praveen. And I think the first question that we have is, increased flexibility of electronic timekeeping, again, is something that you want to make your ally and not think of as your enemy. And certainly, I would say, as I've said for years, that the answer to many of the timekeeping questions we've talked about is more time clocks closer to workstations. It's not time clocks too far away. There are some fascinating questions to look at. One is, what do we do about overtime exempt employees? Can we require them to punch a time clock? And I have a couple observations on that. One is, if you're thinking that the number of hours that an exempt employee puts in and their punctuality and their departure are really the most important things about that employee, sounds to me that that's more of a non-exempt employee than an exempt employee. I generally recommend or find it appropriate for an employer to keep track of attendance for exempt employees, in the sense of you fill in times that you are absent so that we know if we have to pay you vacation pay, sick leave, jury pay, or the like, and not track hours. Where employers have tracked hours for exempt employees, and because the tracked hours generally don't impact an exempt employee's pay, often the employer sort of gets hung by that when the employee files an overtime claim, because the employee has been inflating their hours and the employer hasn't done anything about it because it never impacted anything, and the manager of that employee was too busy to look or question what was going on. Another question was whether, again talking about exempt employees, whether you can require exempt employees to use vacation time, and you can do that. You want to be sensitive to the fact that the smallest increment that you can use nationwide is set by the state of Washington, and that is you cannot require an exempt employee to use vacation in an increment of less than an hour. There's a case in California that looked at half-day use of vacation time. I think if you read that case fairly, it would allow you to force the use of vacation time in smaller increments of less than half a day. The federal courts, looking at exempt status and salary pay questions outside of California and Washington, some have said you can require an exempt employee to use vacation in increments of as little as a quarter of an hour. One good question, which I think is important to focus on, was can you deduct time from an employee's time card if you feel the time was padded? And you can correct a time card in order to make it right. But I had a recent case here in California that emphasized the crossover between accurately paying an employee and a public policy wrongful termination claim, because an employee was ultimately terminated for claiming that she had missed meal periods where the employer felt that she was not telling the truth. The problem is, a request to be paid is really basically fairly analogous to any other legal demand on the employer, aka whistleblowing, in the sense that unless the employee lacks a good faith belief, just a good faith belief in that claim, you could conceivably be retaliating against the employee. Let's say a supervisor. Let's assume a black-hearted supervisor, a hypothetical supervisor who keeps denying an employee's request for small amounts of overtime, even though the supervisor knows the employee is working the overtime and needs the overtime because the supervisor just doesn't get the rules right. The employee is eventually disciplined for falsifying that time card. Well, it doesn't take much to see that employee was really fired for claiming to be paid for what the employee is entitled to be paid. So we have to approach, my point really is, we have to approach employees' alleged padding of time or misreporting of time very cautiously, because it does have a crossover into wrongful termination litigation. There were a number of questions about what do we do with small amounts of time at home. And let me go back and touch on that one more time. Basically, as long as an employee can perform that work, when he or she generally chooses, it's not tied to as soon as you get home, right at the end of the commute, or just before you leave in the morning. The recent run of court decisions has been that's okay. The regular workday ended when the employee left work and started the commute home. If the employee has to do something at any point of their choice in the evening, it's not going to make the commute compensable. of course, if the amount of work, and there were a couple of questions about, well, what happens if I call an employee at home? Do I have to pay the employee for the time? Well, I have two thoughts on that. One, legally, we look at the de minimis doctrine, and it's 3 requirements. How often does it happen? What's the administrative difficulty of recording the time, and how much time is really at issue? And if on the 3rd Tuesday of August, you called an employee at home and chatted with the employee for 5 minutes about something that was left undone in the office, and it didn't happen otherwise, you could well consider that to be de minimis. But on the practical side of things, if you want the employee to answer the phone when you call in the evening at dinner time, perhaps, you'd want to pay the employee for the time. You would just want to be able to say, hey, it's work time. I've engaged you. I've asked you to do something for me, and pay whatever reasonable increment of time is appropriate. There were a number of questions about, what do I do with employees who punch in really early? And you have a bit of a practical problem there. And sometimes the location of the break room or the entrance lobby and where the time clock is important. And again, the ability to have time clocks close to the work area can help avoid that. I was working with a cannery out here in California recently where we were doing a variety of redesign issues, and one of the things that we were very attuned to was making sure that employees had a way to get to the break room where they could gather, and because hours of canneries are very varying, they could have a meal or a snack if they wanted to, and the time clock was between the break room and the work area. So employees could arrive early, do whatever they wanted to do, but the setup was such that you had to go somewhere else. And quite frankly, if someone's showing up early and they're starting work early, you got to pay them for the time. I had the same wrongful termination case that I spoke about briefly was originally, had to do with other issues, but then the supervisor volunteered in the middle of her deposition that, she always showed up early and she'd start work, and that was one of the problems, that she would always show up early. And the next question, of course, was, well, did you pay her for the time? And the answer was no, and a wrongful termination case became a wage and hour case. So if you don't want to pay for the time, you need to make sure the employee is not working. It's your affirmative burden to get there. Number of questions about short meal periods. What happens if employees go back to lunch early? Technically, in an omniscient view of the world, you probably would not have a legal liability if somebody left a little bit early. It was their choice to leave the lunchroom. They'd finished lunch. They just wanted to go back to work because they are that kind of person. The problem is, years on, if that employee falls out of love with his or her employer, which inevitably happens at some point by termination, resignation, layoff, or retirement, you have a record of short meal periods. Some employers actually have gone to lockout systems where you cannot punch back in from lunch until you've taken your full 30 minutes. And if you have a large dispersed workforce, that might be the best answer for you in the program. Couple of other questions about being called at home for brief periods of time. One was, does that trigger reporting pay? Because there are a number of states, California, there's reporting pay for minors. In Oregon for minors only. There's reporting pay in Washington, D.C., New Jersey, 1 hour. Washington, D.C. has a very burdensome reporting pay statute. New York is similar, of 4 hours. New York is like 4 hours at the minimum wage, so if you're paying an hourly rate which is well above the New York minimum wage, you shouldn't have an issue. And then you see reporting pay in the New England states as well. In fact, I think most of the New England states have a reporting pay statute, so very interesting geographic dispersion there. Does a call at home trigger reporting pay? I would say no. Interestingly enough, I've not been able to find definitive guidance on that subject. I did talk to the New Hampshire Department of Labor about that issue. I had an employee for a client who complained to the New Hampshire Department of Labor, and their initial position was, yes, just calling the employee at home would trigger reporting pay, but we managed to negotiate our way through that for a variety of reasons and never had to force the issue. So definitely a good question. When we talk about meal periods, and that's a little bit, we'll go back to, it's a very sensitive issue, especially for those of us in California where, the state of California called that 1 hour of pay premium pay, but we all know it's a penalty. A waived meal period for California purposes means that the employee could have timely, that is, before working more than 5 hours for the first meal, before working 10 hours for the second meal, taken the full half-hour off-duty, uninterrupted meal period when the employee was free to leave the premises. And if the employee is offered that opportunity and declines it, or decides to take the meal period late, or decides to take a short meal period, technically that's a waived meal period. And that's, but again, you don't want to create a record of someone always taking 15-minute meal periods and then have to sort out later whether that was voluntary or not. I will use the word preach. I preach to employers that the best record that meal periods were provided is that they were regularly taken and accurately recorded as being the full half hour long. If you have a small working environment, close working environment in a department of their few employees, you might cut a little slack from that. But quite frankly, if you have a large workforce, dispersed workforce, your policy should be the state requires, and this should be true in any state of the 21 states that require meal periods. The state requires meal periods, and it is our policy that you will take one for your health and welfare and relaxation and be able to return to work refreshed. Let's see, there were a couple of questions that went back earlier into the program and issues that had been raised and I think addressed as we went along. Some asked for repetition of some of the materials, and I think at this point, as we're coming very close to the end of the program, I'm going to turn the program back over to Keith, and Keith will explain how you can obtain materials and what we will be sending out by way of materials in the program. With that, and before we go, I'd like to thank Praveen very much for his support and sponsorship of this program. I'd like to thank Keith Upton for hosting the program on behalf of Littler. I'd like to thank Adam Roth, an associate here at Littler, who did a great deal of work to help prepare the program. And with that, Keith, can you tell us about what people can expect after the program?
Yes, as a reminder, there will be a follow-up email that will be sent out later tomorrow. Within that email, there will be the presentation, the CLE request form, and PHR/SPHR certificate. And there will also be a link to the recording, which will be included in that, and then a link to the various Replicon materials as well. And with that, I'd like to thank everybody, and you can now disconnect.